Getting a divorce, you've got kids, guess what? The custody game has just changed.
This is the American Law Journal.
10 years in the making, and it's done. And now, if you have a child custody question, whether it's about relocation, grandparents' rights, or evaluating your ex-spouse, there's a whole new law to look at. Good evening, I'm Christopher Naughton. We will answer your questions on these new child custody laws tonight. But we're going to look at something right now that is not part of the new law, although I think it's indicative of the way child custody laws are trending, at least in Pennsylvania. Jocelyn Mose, 69 News, explains.
We are here in the name of Kimberly Godshall Carl.
In November of 2002, Kimberly Godshall Carl lost her life at the hands of her husband, Joe Carl, while the couple's daughter was in a crib nearby.
Imagine being 1 year old and having your mother murdered in the next room.
Carl is in jail, and the daughter now lives with relatives. Under a court ruling, Carl is allowed to send letters and drawings to her.
She knows what her dad did to her mother, so this is just being brought up every month, sometimes twice a month with holidays.
Kimberly's mother, Fairly Godshall, is now fighting to change state law relating to child custody. Kimberly's law says that no court shall award custody or allow contact or communication by a parent who was convicted of first-degree murder of the other parent. That is, unless the child is old enough to consent.
House Bill 2407 is not only about my granddaughter, but is for any child who finds themselves in this situation.
Godshall, along with Heidi Marco from the Beginning Over Foundation, testified in front of the House Judiciary Committee.
They're lying in wait, planning a murder. I believe a criminal mindset should not be allowed around children.
Kimberly's law was first introduced last year. State lawmakers say they still have a lot of hurdles to clear.
This is an incredibly complex area because no matter which way you turn, somebody's interests are affected.
Lawmakers say they plan to gather more information and give it a closer look in the fall session. Meantime, Godshall and the Beginning Over Foundation say they're not going to let Kimberly's law go away. In Harrisburg, Jocelyn Mose, 69 News.
And again, that's not part of this new law that has just come down weeks ago in Pennsylvania, but I think it does, again, indicate where Pennsylvania and maybe some other states are trending when it comes to custody matters. Three guests weigh in on this new law tonight. We hope to hear from you tonight, the families, the judges, the lawyers as well. Don Spry joins us once again, 20 years running now on the program for Don Spry. And Don has taken family law cases throughout every stage of court in Pennsylvania. He argued the Chen case before the Pennsylvania court just a few years ago. Kathy Mandarino joins us tonight, and after 18 years, she's stepping down. She has served in the Pennsylvania House of Representatives for those 18 years. It was her impetus that got this bill up and running once again. It's been 10 years coming. She gave it to Ed Rendell. Posed it to Ed Rendell last November, and he signed it. It is now law. And keeping us all honest tonight is Bonnie Frost with Einhorn Harris, Asher Barbarito and Frost. Bonnie hails from a New Jersey law firm. It is the most prominent, or certainly the largest family law practice, and a very prominent family law practice in the state of New Jersey. And Bonnie, we're going to ask you tonight how the New Jersey practitioner may be impacted by these new laws. Quick reminder, folks, if you need more information once we leave the air, it's very simple. Go to our website, lawjournaltv.com. You can also check us out on Facebook. Just type in American Law Journal. We are now on iTunes as well. Go to any of those media, get your law on demand. And a quick reminder, we are coming to you live tonight, whether you're watching us here on WFMZ TV or streaming. So you can call us 1-800-426-4625. There's our number, streaming live. And after we leave the air here, at 7:30. We'll continue to stream over at WFMZ.com. Kathy, let me go to you first, since you were the force that got this this moving again. This is, again, 10 years in the making, but one of the, shall we say, controversial elements of this law deals with criminal matters. Now, we just saw that package, that feature report, that talked about women and who have experienced a crime. Well, actually, let's go since we've got it up here. Let's go ahead and go to the to the graphic here. The change now in this law is it's now one comprehensive law. They've taken all common law and case law, wrapped it into one statute. There are now 16 factors that you've got to be aware of if you're looking for custody. The judges are now required to explain the factors influencing their decisions. The law now codifies gender neutrality in awarding custody. And let's go ahead and take a look at these last 2 points, because that's what I wanted to pose to you, Kathy, and that is before custody is granted, if a petitioner has been accused or is actually convicted of a crime, he or she must be evaluated. And not only that, but if any members of the petitioner's household has been convicted of one of more than 30 crimes, they must be evaluated. Doesn't that pose an undue burden on the family court system?
Well, you have to remember, Christopher, that the focus has to be on the best interests of the child. So what we're trying to do here is to make sure that we are not, by the nature of our law, putting children at risk. This is a highly emotional area, family law. It's a highly sensitive area. But the bottom line is kids need to be safe. The other point, there were a lot of points in this law that took a lot of compromise to get through. The criminal aspects of it were not very controversial when it went through the legislature. There was not a lot of dissent that was the way we needed to move.
So lawyers are just talking about it now. I've heard that now if someone is accused of a DUI or actually convicted of a DUI or small possession of marijuana or petty theft, now all of a sudden that gets thrown into the mix, whereas before it may not have been considered by a judge.
Well, it's a factor that needs to be considered. You want to make sure that you're putting a child in the hands of somebody that's safe and responsible. And if the level of substance abuse has risen to a point where that child may not be safe, it's absolutely a factor that ought to be considered.
Don, I hear, however, that the family law courts are saying we don't have the resources to start looking at every aspect of a person's criminal background. There may be federal violations. They may not have easy access to that. And not only that, find out who's in that person's household and then check out their criminal background. It sounds like it may delay child custody cases, and I think that's part of the hue and cry.
That possibility exists. It is difficult to get the federal information, but and it may have more of an impact on people that are unrepresented. Most lawyers that do this work would have brought that information before a judge anyway. I mean, if you have a situation where somebody has a DUI, it's likely that it would have come out in a trial or a hearing that there was a concern about a child being in a car with someone who has a drinking problem. So this, you know, the law pretty much codifies what a lot of us were doing anyway.
Okay.
But having said that, you know, people that are unrepresented may not know to bring this information out, and a judge has a checklist of what to look for. And the new law does require counseling in those circumstances to make sure that this person or the person in the household is not going to adversely affect the child.
So, Kathy, is there evaluation, whereas maybe before there was an evaluation? I would have to expect that if one of the parties, especially the petitioner, had a criminal conviction, they had to be evaluated by someone, correct?
Well, you're going to have to roll back to Donald in terms of the practitioner aspect of that. What I can say is I very much expect that these issues will come up in the court the way they come up traditionally now, whether the litigants are represented or pro se. One or the other party will bring it up if they believe it is a material factor for the judge to consider.
And Bonnie, in New Jersey, again, you may not have this in one of your statutes, but if someone has a criminal conviction, don't they get evaluated by the courts first?
Well, I guess I'm somewhat interested in the process that Pennsylvania goes through, because if in New Jersey, if there is a true custody dispute which is going on and the parents are at odds, whether it's be custody or parenting time, there will be an evaluation, usually by a forensic psychologist, and as Don said, one parent will bring up that the other one has a drinking problem or has some drug problems. There will be an evaluation by that kind of specialist. If there's been a domestic violence incident, that person will be evaluated potentially by an anger management specialist in the mental health field. So a lot of these evaluations would have been all part of the litigation process before the determination is made. And if custody is really in dispute, it's probably going to take a year to get through the New Jersey systems.
Right. So does this slow down, again, if we're looking into criminal backgrounds to what used to be considered small criminal matters, Don, is this going to slow it down, do you think?
I don't think that this legislation affects small criminal matters. I mean, if you look at the law and what the legislature has defined as crimes which are a concern, they're pretty heavy-duty crimes. There's sexual assaults, there's rapes, there's murder.
But for example, a DUI, let's say somebody comes up at a .08, you know, and again, I've heard attorneys say, you know, sometimes the spouse that's been convicted of a DUI really is the most appropriate custodian for that child.
It depends, you know, you're comparing parents to each other, not perfect people. But by the same token, I think any court is going to be interested in looking into alcohol as an issue if there's been a DUI. Whether or not the court determines that it's a problem that's going to prevent a custody award is another question. But I think it has to be considered.
Christopher, and
yes.
I think Donald's point needs to be amplified. This is the court's decision about what's in the best interest of the child with that particular parent in mind. Nothing is prescriptive in here. Nothing is saying that if the court finds this, they must then find against that particular parent. It's just putting all of the potential risk factors on the table when making a decision about what's best for the child.
So a lot of this, as Don alluded to, and again, a lot of other Pennsylvania family law practitioners have alluded to, that maybe there's nothing completely new under the sun here, bits and pieces, but we've codified, we've basically taken what judges have said in cases. We've taken case law, we've taken the common law, and now we've stuck it into a statute to make it a little clearer for judges and for lawyers and for those families who have to go into family court.
And I think that's a good point, because more and more families go into family court unrepresented. They go in as pro se litigants. They don't have attorneys of their own. They are trying to navigate a situation and a system that they don't understand when they are very emotional. And so the clearer that we can make the law for them to understand, the better the process will be for all involved.
And that's got to run, you know, that's got to be consistent across state lines as well. You know, Bonnie, that if you're up against someone who is pro se, they're already 2 or 3 clicks behind, you know, the possibility of getting what they want.
Sometimes.
Sometimes, really?
Well,
why wouldn't it be? I mean, just
educate
us.
I think that sometimes, while we have a lot of case law in New Jersey that says that if you represent yourself, you have to know what a lawyer is supposed to know, and a judge is supposed to look at that person as if he or she were a lawyer. But the reality is, while they all say we won't give legal advice, there's a bit of empathy for the pro se litigant, especially if that litigant's respectful and is really trying to do the right thing as they go through the system. So
judges sometimes will maybe their balancing of the playing field may be just a slightly heavier hand on that side of the.
Sometimes it is.
I think especially in custody cases, because I mean, if you know what a judge really is looking at is the best interest of the child, and it doesn't do the best interest of the child justice if a parent is pro se and can't bring out certain information that may be important. So I mean, I think in Pennsylvania, a judge has a duty to create a full and complete record.
You know, Kathy, again, we could jump in almost anywhere, and I jumped in with the criminal aspects, but let's take a look at some of the other issues, and I'm going to give you the shot coming out of the box here. I mean, again, we could talk about grandparents' rights, relocation. We talked a little bit about pro se, family plans, parents' plans. What do you think is the most important place, or the most important place to start here?
I'd start in 2 places. The first is, for the first time in Pennsylvania, we are requiring that the judge put on the record the reasons that he or she made the decision that they made. They never had to before. Litigants would be confused or not understanding why they got the result that they got. Now they'll know. We've listed specific factors in the law that the judge is to consider, and required the reasons for the decision on the law. We specifically also, the second point I want to make is put language in the law reminding the courts and all involved that the law in custody, as in all respects, needs to be gender neutral. There's no presumption for either parent in awarding any custody. And I think those 2 things will go a long way in helping litigants think and understand what's going on and know that the court is being fair to them in this situation.
We always presumed it was gender neutral, but we've heard from lots of men's group that that's not the case.
Well, I think that that's a perception, and sometimes perception is reality, and sometimes perception is just I didn't get the result I wanted. But now I think it will make it much clearer, and I think it will be very difficult if you are a jurist who was displaying any sort of gender bias. It will be very difficult in light of having to specifically take into account all of the factors involved and put your reasons for your decision on the record. I think in any instances where that was happening, it's our hope that it will be cleaned up.
That is a big deal. So now when you go into court and a judge awards custody, you know, the client doesn't look at the attorney and say, what just happened? And the attorney says, I don't know.
Well, it's true. You could go through under the old law, you could go through a custody trial, and at the end of the day, you got a custody award one way or the other, and a visitation or a partial custody schedule, and that was it.
Right.
But the way you would get an opinion is if somebody filed an appeal to the appellate court, there would be an opinion written, but not that many people can afford an appeal.
Yes.
And so, you know, my experience typically was in the counties that I practice in that I did get opinions in custody cases. The judges did write opinions, and so I didn't have that problem.
And what about New Jersey? Do your judges have to enumerate?
Yes.
They have to.
They have to.
Right.
In every motion that's made and in every decision, there has to be a statement of facts and a statement of reasons, tying the two together. So.
That's not why you called Don earlier and said, what's the big deal?
I did. I sort of said, what's so important about that? It is
We've
very
chided
different.
Don for years here on the program about Pennsylvania, you know, maybe being a little bit behind in certain areas of the law, but in some ways, again, I think it does create some sort of clarity. But is it statutory or is it case law?
It's rules.
It's rules. It's rules.
Promulgated by the Supreme Court that every judge.
Judge awards custody. He's got to say why he's doing it.
Every decision.
Right, okay.
Whether it's custody or what it is.
All right, now in
decision.
Pennsylvania, they've got the 16, the factors, and again, they've taken most of that from case law. What do they do in New Jersey? Do they have a checklist in Jersey as well?
Well, there is a list, but it's again, it's the best interest of the child. Part of what they have to consider is the age of the child. Do the parents communicate? How do they get along? What is their relationship? They're going to talk about the health of the child, health of the parents, all sorts of things that would affect rearing a child. What goes into making the best life for that child? So some of the things that Pennsylvania enumerates, we do as well. I mean, and it's part of our checklist, sort of, but that's what we have as well.
Let's get to some of your telephone calls. Again, we are coming to you live on WFMZ TV tonight, and at 7:30, we'll be switching over to WFMZ.com, so join us there as we continue to stream live. Let's go to Colleen in Easton first. Colleen, what's your question?
Hi, I would like to know, I got custody of my son in 2009. Now his father's trying to take me back to have that revised. How often can he do this?
As often as there's a material change in circumstances, right?
Yeah, basically, to be successful, he must be alleging that there's something different now than when